I'm Drew Stevenson. This is a lecture for my Statutory Interpretation and Regulation class, or Leg-Reg, about the case Blanchard v. Bergeron, a U.S. Supreme Court case from 1989, where we see sort of textualists, modern textualists, and encountering and dealing with legislative history. This is, and the facts of the case are about contingency fees and attorney's fees, but we're really honestly reading the case just to look at how the court uses or abuses legislative history in interpreting a statute. So don't get too hung up on the facts of this case or the parties or the holding, because we're not reading this to learn a rule of law. You're reading it so you can start to understand the use and abuse of legislative history in litigation, what you should do as an attorney, when you should cite it, how we use it, how we use different parts of legislative history, and so forth. And there's a couple of things that are complicated about this particular case. And this is a case where the legislative history discusses court precedent. And so we have this sort of like virtual loop or a conceptual loop of, we know that courts are pretty good at interpreting their own precedent, deciding what's binding precedent and what's persuasive authority and so forth. And we know that courts can want to defer to the will of the legislature. But what happens when we have some comments from some people in the legislature about their interpretation of prior precedent and how that affects what they think that this law means? And that's the big thing that you should be focusing on when you read or study this case. So let's look at what happened. This is one of our cases about Section 1988 in the Federal Code in 42 U.S.C. 1988. And so remember that Section 1983 provides for civil rights sort of torts type actions against state actors. And then 1988 is basically the attorney's fees provision that can give a prevailing civil rights plaintiff recovery of reasonable attorney's fees as part of the costs if you're suing under certain specific statutes like 1983. And so this is a fee transferring statute where basically the plaintiff can get their attorney's fees out of the defendant in addition to whatever damages they recovered. By the way, Congress thought this was particularly necessary because a lot of times in civil rights cases, you're actually asking for injunctive relief. So as an attorney, if you take one of these cases, a lot of times the traditional damages, if you're working on a contingent fee, are rather low, and the cases are a lot of work, and a lot of what you're trying to do is get the government to stop violating somebody's rights, right? So you're looking for mostly a change in conduct. So Blanchard brings a case and prevails under a qualifying civil rights statute and wanted to recover attorney's fees. But this is one of these cases where Blanchard's attorney had, in fact, agreed to the representation under a contingent fee. And so, in other words, the Blanchard expected to get some money damages if they won, and the attorney was supposed to get a percentage of that. And again, probably what's really going on here is that wasn't very much. Most of what you win in a civil rights case is reform, is an injunction where the government stops violating your civil rights. But in this case, they also got some compensation. And so basically, Blanchard's lawyer then was saying, I want to recover, I want attorney's fees that you would normally get, which are basically paid by the hour. So under Section 1988, the reasonable attorney's fees are typically for a civil rights case, you're going to put in the number of hours that you worked on the case, your hourly billing, your timesheets, and get compensated on an hourly basis from the other party. Bergeron, who's the defendant in this case, which would have been the state actor, said that a reasonable attorney's fees has to be capped by whatever contract Blanchard originally had with his or her lawyer. That basically, if you were going to do the case and agree to accept a certain amount, then that should define reasonable attorney's fees. You just settled that with how much you were going to pay. The argument is, why should a lawyer get more than they agreed to do the case for now that they win, just because the other side is paying for it? If the other side has to pay, they should pay what you would have paid, your own lawyer, in other words. So the court's discussion of what constitutes a reasonable attorney's fees then turns to the legislative history, which is why this is even in your casebook. So that's the part you should be focusing on. Attorney's fees stuff is interesting to me because I also teach professional responsibility, but let's focus on this. The House and Senate reports, so we have these committee reports. Remember, bills go through committees, which are made up of members of each chamber in the House and Senate respectively. And they work up the final draft of the bill that goes to the floor of their chamber for debate and vote. And they usually send it along with a really thick report that kind of summarizes their policy findings and maybe has transcripts of hearings they held and different studies that they gathered and so forth. And in these reports, there was a reference to this older case. There was a lower court case, not a U.S. Supreme Court case, that had set out a 12-factor test for deciding what counts as a reasonable attorney's fee in these under 1988 in a civil rights case. And the dicta said that the fee award should never exceed the amount of a prevailing plaintiff is bound to pay. In other words, the House and committee reports referred to a case, and then if you go to that case has a note in it, a footnote saying, of course, the other side should never have to pay your lawyer more than you were going to pay your lawyer. So the committee reports also distinguished 3 district court cases, which the committee viewed as correctly applying the Johnson test to consider contingent fee agreement as non-dispositive factor in determining reasonableness. In other words, we had some cases that went the other way, and they basically explained those 3 cases away. And so I want my students, if you're getting a little lost, basically our legislative history is discussing this cluster of lower court opinions that were all just persuasive precedent, and basically one case, the Johnson case, and then what some other courts had said in disagreement, and then the committee, these congressmen are saying why they don't think those 3 other cases matter and Johnson does. And so the inference here is that some people in Congress endorsed a particular line of lower court cases and rejected others. So the Supreme Court, let's talk about that, here in 1989, concludes that an attorney's fee was not per se unreasonable if it exceeded the amount the plaintiff was contractually obligated to pay. Well, we have a strident dissent from Justice Scalia. That's the only kind of dissent he writes. A concurring opinion, that's also usually strident, criticizing the court's reliance on cases cited in the committee reports. And as an aside, I want to say something about Justice Scalia. Justice Scalia got on the court in the 1980s and kind of had an agenda of advocating this modern jurisprudential ideology or approach called textualism, and which is a little bit like the parole evidence rule in contracts. I'm making an imperfect analogy where we're not going to look at outside materials to figure out what a statute means. He had some exceptions. He would look at how the words were used in other statutes or in other cases and so forth. But what he really objected to was the reliance on legislative history, which by the time he came on the court was pervasive. Like at courts all over the country were looking to legislative history to interpret statutes more than the statute itself. And so instead of proposing a moderate view, like maybe we should start with the statute, he wanted to go with a kind of traditional English view that no legislative history should ever be referenced. And what he did, and this is why a lot of these cases end up in our casebook, is even when he agreed with the outcome of the case, he would write a concurring opinion saying, the majority got it right, but it's a real shame that they're still talking about legislative history. We should never, ever, ever talk about legislative history. And that's part of why this case is in our casebook, because we're looking at what the majority does and then Scalia's concurrence explaining why he is upset with that and that they could have gotten the result another way. And I've made a separate video sort of talking about some of these problems with legislative history. And in each concurrence, he sort of, so there's some that he comes back to again and again, and other times he would work in a new objection to it. So one is what I'm going to summarize as bicameralism and presentment. So you might remember that the Constitution requires a law to get passed by both houses of Congress, not just one, and then go to the president, be presented to the president for signature or veto. And his point is the legislative history doesn't go through both houses, right? So the House of Representatives has its committee reports, but the Senate never reads the House committee reports. They read Senate committee reports, and vice versa. The House never reads, when they're voting on a bill, they're voting on their version of the bill. They're not looking at what Senate committee reports are saying. And no one thinks that any president of the United States has ever bothered reading Senate committee reports, right, before signing or vetoing a law. So he's basically saying the stuff that goes through the constitutional process for lawmaking is what's actually in the code, not what's in the legislative history. This is a plausible point, right? An argument that it's basically unconstitutional to treat the legislative history as controlling. And now, as you can imagine, someone could say, we're not doing that. We're not treating the legislative history like it's law. We're just looking at it for clues about how to interpret vague terms in the statute. But he says, look, if this isn't the way you're deciding cases, then that's the law in practice. And it's not fair that the other house of Congress never saw this before they voted, and the president didn't get to sign or veto the legislative history. And so, and this kind of feeds into his second point in his concurrence here, even within one chamber, right? He says, not many people read these reports, right? So congressmen show up for the vote, and a lot of times they ask their aides and stuff like, what's going on with this statute? Or is this something I support? Or they vote on party lines, or they've worked out a deal with the sponsor of the bill. I'll vote for yours if you vote for mine. But he doesn't think that very many people in Congress are actually sitting down and reading this. And in recent times, I'm recording this in 2020, we just passed another stimulus bill that basically no one had read before they voted on it, and in its entirety, because some laws are hundreds or thousands of pages, and so much less do they read committee reports. There's also concerns, he says, that special interest groups can manipulate the report writing process. In other words, if you have a special interest group or lobbyists, send some lobbyists to testify at Senate committee hearings and House subcommittee hearings, and talk about what the words mean so to sort of do a preemptive attack against anticipated litigation that you're going to have under this statute in the future. And you can basically kind of pad the legislative history with stuff that will support you. And if you think about it, like if you're worried about being a tort defendant, right? You're a big deep pocket corporation, then that's the very type of thing you might have an interest in. Although this particular statute is a civil rights one, so I think that his concern about interest group manipulation is a little less of a concern. His main point is that we don't have any reason to believe that legislators who weren't on that committee read or base their votes on the content of the legislative history. If they read anything, they just read the bill itself and thought they were voting on that. This leaves us with some questions. Does an open-ended standard in a statute actually signal Congress's intention to just delegate that decision to the judiciary? In other words, if Scalia doesn't want us to look at legislative history, does this, and he says, because he thinks one of his concerns is it allows his judges to kind of just go rogue, but maybe then what he's really saying is that when there is an ambiguous word in the statute, that Congress has essentially left it up to the judiciary to figure out what things mean and fill in gaps where there's statutory silence and so forth. So in other words, this is a type of delegation issue. And do we have delegation concerns? Can Congress just start passing really vague statutes and not do their job and say, well, the judges will figure out what the law should be? And secondly, does reliance on policy details from a committee report change the adopted text? So Scalia seems to think that when you look at legislative history, that you're elevating those House committee reports and so forth to the level of basically being the law, telling us what the law is. And the people who like legislative history might say no, but why wouldn't we want all the information we can get about that would clue us into what Congress actually meant by the words, and so that we can make sure that the courts aren't thwarting the will of Congress. And third, does this reliance on legislative history undermine democratic accountability? This is another way of like thinking about the bicameralism and presentment problem, is that right, if most Americans don't even know what Congress is doing most of the time and have never heard of most of the laws that are getting passed, right, except for the really controversial ones that garner media attention. And so most Americans are never going to sit down and read the text of a statute, but much less are they reading legislative history and then holding their congressmen accountable. Instead, people tend to go into the voting booth and vote either on party lines or because they know this person and like their local senator or representative or something like that. And he thinks that there's something here about using the legislative history that's very undemocratic because of the lack of transparency for the general public and the citizenry. Okay, that concludes our little lecture about Blanchard v. Bergeron.